More than a month after 16 children were removed from a small home in rural Ohio, the case that shocked the country has entered a very different phase. The disturbing conditions inside the house are no longer the only question before the court. Now, the court is asking whether the adults accused of allowing those conditions to exist are mentally capable of standing trial at all. And for one defendant, the question goes even further. Elizabeth Siders, the 33-year-old mother of the 16 children, has now been ordered to undergo 2 separate mental health evaluations. One will determine whether she is competent to stand trial. The other will examine whether she was legally sane at the time the alleged offenses occurred. Those may sound like similar questions. Legally, they are very different, and the distinction could dramatically change what happens next in one of Ohio's most disturbing child endangerment cases. On August 10th, a Vinton County judge granted a request from Elizabeth Siders' attorney for formal mental health evaluations. The request came roughly 6 weeks after law enforcement entered a residence in Hamden, Ohio, and found 16 children living in conditions authorities described as deplorable. Elizabeth is charged with 16 felony counts of child endangering. Her husband, Gary Siders Jr., and his parents, Gary Siders Sr. and Christina Siders, face the same number of counts. All 4 have been accused. None has been convicted. And now, all 4 are connected to competency evaluations that could determine whether their criminal cases can move forward normally. For viewers who followed the case from the beginning, this is an important shift. The first stage of the investigation focused on what authorities said they found inside the home. Officials described a small room where the children had allegedly spent much of their lives. Investigators said the room was contaminated with human waste. Some of the children reportedly had serious medical and developmental problems. Several required hospitalization. Authorities also said none of the children was enrolled in school when they were found. Those allegations generated immediate outrage. But criminal cases are not decided by outrage. They are decided through evidence, legal procedure, and the constitutional rights of the accused. And that is where the Siders case now becomes more complicated. Elizabeth Siders' attorney raised concerns about whether she understands what is happening around her and whether she is capable of meaningfully participating in her defense. That is what a competency evaluation is designed to examine. Competency does not ask whether someone committed a crime. It does not ask whether that person is innocent. It does not even primarily ask what the person's mental state was years ago. It asks about the present. Can the defendant understand the nature and purpose of the court proceedings? Can the defendant communicate with an attorney? Can the defendant help prepare a defense? If the answer is no, the criminal case cannot simply continue as if nothing is wrong. That principle exists because the American justice system generally does not permit the prosecution of a person who is incapable of understanding the proceedings against them. But Elizabeth's situation contains another layer. Her attorney also requested an evaluation related to a possible insanity defense. This examination looks backward rather than forward. Under Ohio law, the question is whether, at the time of the alleged offense, a severe mental disease or defect prevented the defendant from knowing that the conduct was wrong. That is a much narrower standard than many people assume. Mental illness by itself does not automatically establish legal insanity. Unusual behavior does not automatically establish insanity. A diagnosis does not automatically establish insanity. And being found incompetent today does not automatically mean a person was legally insane when the alleged crime occurred. Those are separate findings. That distinction may become crucial in this case. Elizabeth's attorney has argued that there is reason to examine whether she understood the nature or wrongfulness of her actions during the period covered by the charges. The judge has now agreed that the question should be professionally evaluated. That does not mean Elizabeth has been found insane. It does not mean the defense has succeeded. At this stage, it means only that a qualified examiner will investigate the issue and submit a report to the court. According to reporting from Ohio Public Media, that report must be submitted within 30 days of the judge's examination order. The report will be filed under seal. That means the public may not immediately learn all of the medical findings contained inside it. And because the judge has already issued gag orders limiting what attorneys and other parties can publicly say about the case, the flow of information surrounding the investigation has become much more restricted. That silence creates a strange contrast. The original discovery generated national headlines almost instantly. Officials publicly described the condition of the house. Images of the defendants circulated widely. Neighbors were interviewed. Questions were raised about how 16 children could apparently remain largely invisible to schools, doctors, and government agencies for so long. But now, just as the criminal cases are entering one of their most important stages, much of what happens may take place behind closed doors or inside sealed reports. Elizabeth is not the only defendant being examined. The judge has already ordered competency evaluations for Gary Siders Jr., Christina Siders, and Gary Siders Sr. Gary Sr. is reportedly being evaluated for both competency and sanity. Gary Jr. and Christina are being evaluated for competency. That means mental capacity has now become an issue involving every adult defendant in the case. That is unusual enough to raise another question. What happens if more than one member of this family is found incompetent to stand trial? The answer would depend on the individual findings. Each defendant is evaluated separately. There is no automatic family-wide ruling. One defendant could be found competent while another is not. One could potentially require treatment before the case continues. Another could proceed toward trial. The cases could move on different timelines, and that could complicate an already massive prosecution involving 16 alleged child victims and 64 felony counts across 4 defendants. The examiner evaluating Elizabeth has also been asked to consider whether she could become competent within 1 year if she is currently found incompetent. That is important. A finding of incompetency does not necessarily end a prosecution. In many cases, treatment is ordered in an effort to restore competency. If a defendant later becomes capable of understanding the proceedings and assisting counsel, the criminal case can resume. So a competency finding can function more like a pause than an ending. The insanity question is different. If a defendant ultimately establishes the legal requirements for a verdict of not guilty by reason of insanity, the criminal outcome changes much more significantly. But even then, one misconception needs to be avoided. A not guilty by reason of insanity finding does not necessarily mean a defendant simply walks out of the courthouse. Ohio law provides for a separate hearing after such a finding. The court can examine whether the person is mentally ill and subject to court-ordered treatment or whether institutional placement is necessary. In other words, the legal system separates criminal responsibility from the question of whether someone may still require confinement or treatment. That distinction will matter if Elizabeth's defense ever reaches that point. For now, it has not. The evaluation has only been ordered. Another recent development involves Gary Siders Sr. The 73-year-old defendant is now out of jail. According to WOSU, a judge approved a $300,000 recognizance bond, allowing him to leave custody while remaining under electronic monitoring. Gary Sr. had reportedly experienced serious medical problems while jailed and had spent weeks receiving medical care. His wife, son, and daughter-in-law remained incarcerated at the time of that update. His release caused strong reactions online, but a recognizance bond is not an acquittal. It does not erase the charges, and it does not mean the judge has decided the evidence is weak. Gary Sr. remains a defendant in the case and is still required to appear in court. The change concerns how he is supervised while the case proceeds. His attorney has also said the family has received violent threats and death threats online. That claim comes from the defense and should be understood as such. Whatever anyone thinks about the allegations, threats against defendants, relatives, attorneys, witnesses, or anyone else involved in a criminal case are not part of the justice process. The courts, not social media, will determine criminal responsibility. There is another part of Elizabeth Siders' history that has attracted increasing attention. She was reportedly only 15 years old when she married Gary Siders Jr. in West Virginia. That fact has now become part of a wider political debate over child marriage laws. The current criminal charges should not be confused with that separate policy debate. But Elizabeth's age at the beginning of the marriage has caused some advocates and lawmakers to ask whether minors can become trapped in relationships before they are legally or emotionally equipped to protect themselves. In Ohio, Senate Bill 341 has been introduced to eliminate the existing provision that allows some 17-year-olds to marry. Supporters of the legislation have pointed to cases involving child marriage as evidence that stronger protections may be necessary. The Siders case has added new attention to that discussion. But this also introduces one of the most difficult questions in the entire story. Can someone be both a possible victim in one period of life and later be accused of harming others? Legally, the answer can be yes. A person's own history of trauma or exploitation may be relevant to understanding that person's life. It does not automatically erase responsibility for later conduct, and the existence of alleged victims among the children remains central to the case. That is why the upcoming evaluations should not be treated as an attempt to explain away what authorities say happened inside the Hamden home. Their purpose is much narrower. They are designed to answer questions the law requires the court to answer before prosecution can continue. The children themselves remain largely outside public view. That is appropriate. They are alleged victims, many of them minors, and their privacy is essential. Authorities previously said the children had been placed in temporary custody and were receiving medical and other services. Public officials also acknowledged that caring for a sibling group this large created an extraordinary burden for a small rural county. Vinton County is one of Ohio's least populated counties. A case involving 16 children, 4 adult defendants, medical treatment, child welfare placement, forensic evaluations, and potentially lengthy criminal proceedings can strain resources very quickly. Earlier in the investigation, county officials sought additional financial help because of the cost of handling the case. That means the impact extends well beyond the courtroom. Child welfare workers must determine what each child needs. Medical professionals may have to address years of untreated conditions. Educators may eventually confront large developmental and academic gaps. Therapists may have to help children understand a world they had little contact with. And prosecutors must build cases involving children who may have limited ability to describe what happened to them. Those challenges existed before the competency issue appeared. Now, the legal process may take even longer. The most important evidence in the coming weeks may never be dramatic video or newly released police footage. It may be a clinical report. A psychologist or psychiatrist will assess whether each defendant understands the criminal proceedings. For Elizabeth and Gary Sr., examiners will also examine their mental state during the period connected to the alleged crimes. Those findings could influence the entire structure of the prosecution. If everyone is found competent, the cases can continue toward the next stages of criminal court. If one or more defendants are found incompetent but restorable, treatment may delay proceedings. If an examiner concludes that a defendant is unlikely to regain competency, the court could face much more complicated legal decisions. And if the insanity question becomes part of Elizabeth's eventual defense, prosecutors may have to confront not just what happened in the home, but what Elizabeth understood while it was happening. That would create a case with two very different narratives. The prosecution would focus on the conditions endured by the children and the responsibilities of the adults around them. The defense could focus on mental capacity, developmental history, and whether Elizabeth possessed the state of mind required for criminal responsibility. A jury, or in some circumstances a judge, could eventually be asked to consider both. None of this changes the basic presumption that every defendant is innocent unless proven guilty. It also does not change the fact that 16 children were removed from a home under circumstances authorities considered so serious that each of the 4 adults was charged with 16 felony counts. Both realities can exist at the same time. The allegations can be horrifying, and the defendants can still possess constitutional rights. That tension is exactly what the justice system is designed to handle. For the public, the next major milestone is likely to come when the competency process produces findings, or when the court schedules hearings based on those reports. Because the reports themselves are expected to be sealed, the first public indication may simply be a court ruling stating whether a defendant is competent. That ruling could come without revealing the private medical details behind it. Until then, many of the biggest questions remain unanswered. Will Elizabeth Siders be found competent to face 16 felony charges? Will experts conclude that she understood the wrongfulness of her alleged conduct? Will Gary Siders Sr.'s evaluation raise the same questions? Will Gary Jr. and Christina be cleared to proceed toward trial? And if different defendants receive different findings, will this family eventually face justice together, or will their cases split onto completely different legal paths? When 16 children were first found inside that Ohio home, the central mystery was how a family this large could remain hidden in plain sight. Now, another mystery is emerging. Not simply what happened inside the house, but whether the 4 adults accused of allowing it to happen are legally capable of answering for it in court. The next reports filed in Vinton County could determine the direction of the entire case. And for 16 children whose lives have already changed completely, the legal process may only be beginning.